On the record, in Bonneville County Case 24-3938, State of Idaho versus Kaitlyn L. Fisher. Ms. Fisher is present, along with counsel Mr. Malik. State of Idaho is present, represented by Mr. Harris. We're ready for a scheduled sentencing. We're ready to proceed in this matter, Mr. Malik.
We are, Your Honor.
State ready, Mr. Harris.
Yes, Your Honor.
Ms. Fisher, let me read the history of this case. You had an arraignment where you informed that multiple charges have been filed against you by the State of Idaho. Let me pull one other thing up. There was a total of total of 15 charges filed against you. You pled not guilty, however, later, pursuant to a plea agreement, pled guilty to count 1, grand theft, count 4, income tax evasion, and count 8, perjury. The state agreed to dismiss the remaining charges. They also agreed to recommend a specific sentence of 3 years fixed and imposed. They were free to argue the indeterminate sentence. You agreed to pay restitution, and you were free to argue at sentencing that this was non-binding upon the court. After I accepted the guilty plea in this matter, ordered a pre-sentence investigation report be prepared. I have received that report and reviewed it. A copy has also been provided to your attorney. So let me first ask, have you had a chance to look at or review that pre-sentence investigation report?
Yes, Your Honor.
Mr. Mount, are there any parts of that report that need to be clarified or corrected?
No, Your Honor. In my sentencing argument, I'll address the recommendation in there. I want to raise some things with the court, but the rest of the report was factual. Thank you.
All right. Ms. Fisher, do you wish to stand by the pleas of guilty previously entered in this case?
I'm sorry.
Do you wish to stand by the plea of guilty you previously entered in this case?
Yes, Your Honor.
Are there any witnesses on behalf of the defendant?
No, Your Honor.
Any witnesses or victim impact statement by the state?
Yes, Your Honor.
Go ahead.
Thank you.
You want to tell me your name, ma'am?
Kathy Chisholm.
Kathy Chisholm. And if you could, you can either sit or stand, depending on how you feel most comfortable. And if you could tell me, once again for the record, for the court reporter, if you could spell your last name. And since Kathy can be spelled differently, if you could spell them both.
Cathy Chisholm.
Thank you. You can go ahead and give your victim impact statement.
I am the transitional Presbyterian stated clerk for Kendall Presbytery, and my statement is on behalf of the Presbytery. Kendall Presbytery is the regional presence of the Presbyterian Church USA, which includes the congregations and ministers of Word and Sacrament in Eastern Idaho. The Presbytery provides support and guidance to churches and their leaders in order to witness to God's love and grace in our communities and the world. Through tithes and offerings, churches provide financial support to the Presbytery, and through the Presbytery to the Synod and General Assembly. The Presbytery elects volunteers to serve on committees and boards which carry out the work of the Presbytery. Currently, a part-time administrator and a part-time executive presbyter and stated clerk are employed by the Presbytery. In the summer of 2018, Kaitlyn Fisher was employed by the Presbytery to serve as administrator. At that time, Candy Wyckoff was serving as administrator, had announced her retirement, and to assist Ms. Fisher in the learning of the duties of the position, the two worked together the rest of the year. Beginning January 2019, Ms. Fisher had sole responsibility for all office correspondence, filing, mail, communications, financial transactions, and bookkeeping, subject to policies, procedures, and direction of the Board of Trustees, Presbytery Council, and ultimately policies and actions by the Presbytery itself. In October of 2022, the chair of the Board of Trustees was alarmed to discover that the balance in the Presbytery checking account was much lower than expected and that a number of unusual transactions appeared in the account statement. We realized immediately that the only person who could have been responsible for these unauthorized transactions was Ms. Fisher. We confronted her, and as head of staff, I dismissed her from the position. I notified our insurance company and filed a police report. At first, we thought the theft of Presbytery funds had only begun that summer, when Ms. Fisher repeatedly communicated concerns about the health of one of her young sons, reported that he needed extensive testing, hospitalizations, and surgery, the travel for which kept her from meeting with me or others regarding Presbytery concerns and financial reports. Throughout her employment, she knew how to play for sympathy and managed to avoid any serious questioning about not completing her work or fulfilling her responsibilities. Ms. Wyckoff agreed to come back to work for the Presbytery and began to try putting our accounts in order and to find the documentation needed to make our formal insurance claim. Because Ms. Fisher had connected Presbytery accounts to her personal accounts through her own email and passwords, it became a nightmare to determine the correct information or regain control of services and subscriptions. Ms. Fisher did not maintain the required voucher system for disbursements or adequate receipts, did not maintain correct entries in QuickBooks, did not keep copies of bank statements or paychecks. Although paid as part-time staff, Ms. Wyckoff worked more than full-time for the next year, organizing records, tracking down account statements, trying to determine disbursement details, and preparing a report. She spent hours on phone calls with the IRS, state tax agency, and other vendors. She had to recreate and update registers for all of the Presbytery accounts. What she discovered was that Ms. Fisher had begun stealing from the Presbytery in January of 2019, as soon as she was working on her own. By the time she was fired, the total that we could document for our insurance claim was around $345,000. The court system calls this a case of grand theft and perjury. The insurance company calls this a case of employee dishonesty. For me, this is a betrayal of trust. The congregations of Kendall Presbytery entrust us with financial resources for the purpose of ministry and mission in God's service. As an employee of the Presbytery, Ms. Fisher was entrusted with the responsibility of proper stewardship of these funds, making deposits and disbursements, maintaining payroll, accounting for and reporting transactions, fund balances, etc. She betrayed that trust. Those of us who met with her and worked with her felt foolish for believing her excuses. We are angry. We are astounded at her brazen and extravagant misuse of funds and dismayed that we failed in our stewardship. Her betrayal damaged the trustworthiness of Kendall Presbytery. We could not order new resources from the PCUSA store until an outstanding debt of about $1,600 was paid. Because she did not prepare tax forms or make payments for several quarters, the Presbytery owed the IRS in unpaid taxes and accrued an additional $15,000 in late fees, penalties, and interest, along with $900 to the Idaho Tax Commission. And we're still dealing with getting the IRS straight. Per capita funds from the congregations were remitted to the Presbytery but not forwarded to the Synod or the General Assembly for 3 years. Because the remittance system went totally online during the time of her employment, no physical invoices were received, and we were unaware these obligations had not been paid. As a denomination, part of our identity is as a connectional system. Our failure to fulfill our obligation to forward per capita funds was a betrayal of our duties as part of the larger church. News reports have confused Kendall Presbytery with a specific congregation. Because our office is located in the building of First Presbyterian Church, and we share a mailing address. That congregation has been mistakenly identified as the victim, and they have received unpleasant communications as a result, and a concern that their reputation has been damaged. Dealing with Ms. Fisher's dishonesty and betrayal of trust has been extremely stressful for those individuals most responsible for dealing with the Presbytery's finances and corporate responsibilities. Sleepless nights, countless hours and days of extra labor, and constant anxiety about what seemed a never-ending investigation resolution have been experienced by Ms. Wyckoff, Ms. Locksterman as chair of trustees, and myself as the executive and ecclesiastical officer. I believe the additional stress has contributed to health issues that I've experienced in the last 2 years. The forensic accounting conducted by the insurance company resulted in reimbursement of almost all of our claim. However, the emotional and reputational consequences of dealing with this experience will continue to linger with us as individuals who were betrayed and as an organization seeking to rebuild our trustworthiness. Speaking on behalf of the Presbytery, we firmly believe Ms. Fisher should be held accountable for actions, especially as blatant and as extravagant as they were. We are concerned that others could be a victim of her dishonesty and betrayal of trust.
Thank you very much. Any other ones, Mr. Harris?
Yes, Your Honor.
Go ahead. If you can still tell me your full name,
Betsy Locksterman,
you're gonna have to spell that last name. I think we get the Betsy, okay, but
Loxterman.
thank you very much. You may go ahead with your statement.
All right. I am the chair of the Board of Trustees of the Presbytery of Kendall. The monetary impact of this crime has been documented. It is substantive and exceeds the settlement from our insurance. Additionally, it made our presbytery appear to be delinquent in our financial obligations to the church and the state. But I would like to share the personal impact of the crime. As chair of the Board of Trustees, I worked closely with Kaitlyn. Because of COVID restrictions, we were not having in-person meetings, but I was the one authorized to sign checks. Once the office had moved from Pocatello to Idaho Falls, I offered to meet her at the office. Kaitlyn always seemed to have reasons to come to Pocatello, so she would come to my house. Often she would have one of her children with her. We chatted about her children and various health issues. When she took her son out of town for treatment, I texted her for updates and to express my concern. I occasionally defended her to others when things didn't get done promptly, reminding them that she was a young mother with 3 young children. I felt there was a friendship there. Even when I first discovered some irregularities in our bank account, I thought there might be an explanation. Discovering the extent of the deception, even to using my name to set up a PayPal account, was shocking. I feel hurt by the abuse of my trust and the betrayal that went on for a number of years from someone I liked and trusted. Though I suffered no actual physical harm, it has been stressful, and there have been sleepless nights wondering how she could treat us this way. My faith teaches me compassion and forgiveness, but I also believe actions demand consequences. I would hate to think she would repeat these deceptions and betrayals in the future.
Thank you very much, Ms. Larson. Any others, Mr. Harris?
No, Your Honor.
Thank you. Mr. Malik, for an sentence in this matter, unless you've already run the client's behalf.
Thank you, Your Honor. I'll start with the PSI. So, Your Honor, we didn't ask for any corrections to the PSI, but I will say that it's noteworthy that in the recommendation there, the PSI investigator skipped over the question of probation. And I think that looking at the rest of the PSI, it's evident why. Because I think that the report comes basically right up to the verge of saying that my client would successfully complete probation, which would be appropriate for the PSI investigator to opine on and make a conclusion regarding, based on the rules. However, the PSI investigator did not do so, but given the low PSI score, or low LSI score, lack of criminal history, family and support networks, that I don't think there's any question that my client would successfully complete probation. Now, I understand the court may have concerns about this as a probation case. However, I do think that some version of events that gets my client on probation would be appropriate, because my client will have restitution to pay. She does have, obligations this court will place upon her, and that all the criteria of sentencing can be met with a sentence that does include probation, because a lengthy prison sentence hanging over my client's head would have a deterrent effect, and some version of whether it's local days in jail, a lengthier work release program, or even a rider program, would have an immediate punishment, so that obviously the victims have had a huge impact. They can see my client be taken away. My client's prepared for that. She's here accepting responsibility, facing the music, taking responsibility for her actions, for the crimes that she committed. Nothing I say here is meant to quibble about the fact that these are serious crimes. However, I do think that it should be noted that my client is not a CPA, and we know that these crimes span a range, right? There are embezzlement cases where you have clearly sophisticated actors who have ethical obligations and know what fiduciary responsibility means and are used to handling large sums of money, and they abuse their power over their victims to defraud others and inflict great harm. And this isn't one of those cases. My client does not have any formal training in accounting, and that's not an excuse. It's just that she's not a sophisticated actor in this situation. She doesn't have the the ethical and accounting training that one might expect to have when having access to the amount of money that she was given access to. Another mitigating factor is the fact that, as was raised by one of the victim impact statements is in the PSI, my client did have legitimate medical expenses and issues that occurred with her family, her husband losing her job, the loss of insurance, combined with COVID and other stressors, specifically financial stressors, and worried about the health and welfare of her child, that did drive this. I think something in the order of $100,000 went straight to medical expenses. And so that's another thing, as we all know, exists on a continuum. There are people who embezzle money and have yachts and accounts in the Cayman Islands, and there are people who pay for mortgages and medical expenses. And this is the latter, and it is not, again, not an excuse. However, just understanding that her actions, while illegal, were not for her comfort and an extravagant lifestyle or anything of that nature. There's no allegation that my client is out buying gold watches or things of that nature and just living high on the hog on someone else's hard-earned or tithe money that people gave out of a sense of religious obligation. And while that does weigh against my client that this money comes from a church, I think without blaming the victims, it should be noted that we're dealing with an organization that does oversee the financial well-being of congregations and have responsibilities upward. And I think the fact that this went on for as long as it did without oversight is unfortunate. and my client is responsible for her own actions without a doubt. However, I think I'd be remiss if I didn't mention, I think this should have been caught earlier. And the PSI, it's unclear, but I wanted to say unequivocally, my client did not hide the accounts from this organization, did not obstruct the organization from being able to access their own financial information. They had access to their financial information all along, as evidenced by the fact that they pulled the financial report and saw that the account was lower than they expected. She was just unsupervised. And clearly used that to her advantage and her family's advantage. But again, not to buy boats, but to pay for medical expenses and a mortgage. So that said, Your Honor, I would ask that you consider a sentence that makes it possible for my client to begin paying back in restitution. I think something like allowing for a local incarceration time with the allowance for work release would accomplish that, while having an effective punishment. Where my client does have young kids and a special needs child. This is, not the children's fault, but they are going to pay a cost. They're going to lose their mother for a period of time. And having to go out, work to pay off her debts, and then report back to the jail to spend nights away from her family, I think in some ways is a more impactful statement of punishment than simply sending her off to IDAHO. I also have concerns with her low PSI that sending her for a lengthy period of time to IDAHO is not efficient use of prison resources with respect to actually having someone in custody 24/7 at the state expense, but then also with her low LSI score, she'll be around people with much higher LSI scores, people who are, forced to be socialized with criminals, and I do have some concerns about that with respect to just the rehabilitative factor, which, while not as important as community safety, is still important. So I think the only thing speaking for a lengthy prison sentence in this case, Your Honor, would be just straight punishment for punishment's sake, which I understand is a legitimate aim of sentencing. However, I do think that all of the other aims of sentencing in this case are pointing to something not necessarily more lenient, but definitely away from a straight prison sentence. Even if there's a significant prison sentence hanging over my client's head, which I stipulate it's appropriate, I think that work release or local incarceration, or at most a rider, with then the opportunity to be on probation, working, paying restitution would be appropriate. I also discovered today my client does have significant mental health challenges, and if Your Honor would like to know more about that, I can provide that to the court at a future date if we need to file a Rule 35 or something like that. Potentially have her apply to mental health court. Something I raised with the prosecution. They didn't necessarily foreclose the option as something they'd be willing to not oppose. But with that, Your Honor, I appreciate your time.
Thanks, sir. Appreciate that, Mr. Malik. Mr. Harris, kind of state's recommendations.
Yes, Your Honor. I'm a little hesitant to start here, but I'll start here anyway and see how far we go. I note that Ms. Fisher does have a short, maybe even described as no criminal history, at least no prior arrests. There was a charge that I read about in the PSI, and that charge I guess I'll look at in a moment. But I'll just note that she has a short history and has cooperated with the state. That's why the state extended this offer in the form of a plea agreement, which we're here under today. And the recommendation from the PSI investigator is incarceration in IDAHO. That will be the state's recommendation. Again, not a surprise based on the plea agreement. And so there's no difference between the PSI and the state in this case. There are some mitigating factors, I'll admit, for Ms. Fisher, which is that she's young at 31. She has very supportive family relationships, married, though separated, and does have a low LSIR of 10. She did not have any criminal interactions with law enforcement, but I noted that the PSI said she had a prior offense at an age that would have put her at about, I thought initially 14. I did a little research and found it was 12 years old. And not going further into that, I would just say that it's my opinion that in that interaction she was as much victim as perpetrator. And I did note one more thing about that at that age, 12, that something like that happening to someone, as serious a charge as it was charged as illegal lascivious, that's the type of thing that can get one's moral compass off course. That's the kind of thing that can cause mental dysfunction when someone has to, at that age, try to understand those types of situations. I can understand that there was history there. But that moral compass brings me to the aggravating factors in this case. And I believe his proper name was Alphonse Capone. We know him historically as Al. Said that a smile will bring you a long way in life. He said a smile and a gun will take you even further. And I know you wonder how that applies here, but it does to some extent apply. Because as I thought about this case recently, I've been thinking about it some time. Violent crime can victimize you often. We see cases like that, burglaries and things like that, home invasions. And they can victimize you of a couple of $100s here or there, maybe $1,000, a ring and a wallet. A crime where you give someone trust, as the victims have mentioned today, can open you up to losses, in this case, in the hundreds of thousands of dollars. These types of crimes where you take advantage of the trust of people and organizations can do far more harm to society and individuals than a thug with a gun. That's what we have, is that situation. I'll note again that, or not again, but note that Ms. Fisher doesn't have any criminal associations. And although she had, we'll call it a little experimentation phase, she doesn't admit to any drug dependency or addictions. She finished high school, received a cosmetology certificate in 2012, but has self-reported that she has had mental health issues that have dogged her, but in general enjoys rearing a family and supporting her children's sports and academic endeavors. I agree with the PSI investigator that Ms. Fisher doesn't have a long criminal history that would indicate an entrenched criminal mindset. And this is the takeaway from why this case, for someone with a short or almost no history, still brought a recommendation of incarceration. However, the extent of her criminal actions over the period of 2 years weighs heavily on the state's recommendation. That is to say, she has a very clean history, but somewhere, for some reason, that moral compass was off enough that she was able to perpetrate this crime over a term of years to the the church and its patrons and her co-workers and all the various people that she reported to and worked with. That is something that it causes one to take pause, and you definitely have to dig into why a person would do that, and there definitely has to be an opportunity for that person to be removed from society because they have that, at this point, definite ability to cause victims and to a great extent. But that person would need to be removed from society for society's protection, and to find out to some extent if they truly are reticent, we'll say, what is the term we're looking for? If they can be programmed to do things differently if given another opportunity to use the trust of a person or organization. I would acknowledge that in reading this that Ms. Fisher is not an accountant, but again, she wouldn't have to have been an accountant to know that what she was doing, that is taking those funds and misappropriating them for her own use, was wrong. And especially when we talk about the numbers we're talking about, that was far beyond accidental misuse or one-time misuse. That was an ongoing series, and it was more than someone can account for by stating that I wasn't an accountant. The state will go ahead and recommend the 3 years fixed and 9 indeterminate, and that sentence be imposed. I would note that on August 8th of this year, the state filed a motion for restitution, $339,175, and would request that that be ordered. Thank you.
Just 1 second. The question I'm looking at, Mr. Harris, is the restitution is one's for the insurance company and the other one is for the Presbytery. Is that still accurate?
That is accurate, Your Honor.
Okay. All right, thank you. Fisher, before I announce sentence in this matter, you need a chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you wish to exercise your right of allocution and address the court, I'll give you that chance. Is there anything you'd like to say?
I just want to say I'm so sorry. I understand that what I did was absolutely wrong, and my actions need to be, accounted for, and I understand that. So I'm here.
Thank you very much. Are you satisfied with the representation of your attorneys?
Yes.
Mr. Mount, is there any legal reason why I should not sentence the defendant today?
No, Your Honor, thank you.
And Ms. Fisher, then based upon your pleas of guilty, judgment of this court that you are guilty of count 1 of grand theft, count 4 of income tax evasion, and count 8 of perjury. I have carefully reviewed the record in this matter. I've read through the precinct's investigation report. I have listened carefully to the arguments of your attorney as well as the state, listened carefully to your statement, listened as well carefully and had reviewed previously the victim impact statements that were submitted. This court has the obligation of reviewing this sentence in light of the objectives of criminal sentencing adopted by the Idaho Supreme Court. Those are the protection of society, deterrence of you and of others, the possibility of rehabilitation and punishment or retribution for wrongdoing. And all those are important in every case, and this court is required to do it. Court, first I want to address a couple of the things, just as I read through the victim impact statements and heard it today. I mean, you stole from good people trying to do good things. And I looked at this and saw that Ms. Wyckoff had worked in that position, that they hired her to take in. She'd worked there for 20 years. Had a very, I would assume, a very open and trusting relationship with the people. And it's my guess that that was their hope for you, to bring you in, to train you, to have you be with them and be a part of their organization for decades. I considered, this is a large amount of money, and I understand your attorney's argument, and I understand he's doing his job, and I know he's not casting, aspersions towards the organization, that he's doing his job and doing what he should do. But I also understand the church's issue. I mean, this was during COVID, they had systems set up, everything had been changed. Things were, some of their safeguards, I'm sure, had been worked around because of COVID and what was happening. There had already been this long period of trust with the previous employer, and they felt like they had that trust with you. It's interesting that both of the victims talked about that betrayal of trust is a huge issue for them personally. Frankly, I understand also the issue of trust with their congregations. I mean, these are religious organizations that rely upon tithes and offerings. And these people donate. And they want to know that their donations go to serve the public good, or to serve the people that they have chosen to help. Not to benefit someone stealing from them. And so I understand their concern about their position in the public and with their own parishioners and the people that attend their congregations, those people that donate. And the fact that it's more difficult for them to accomplish their mission of doing good work, because people are going to be more hesitant to donate, because if they can't manage their money, then they will do something else. So I understand that. And like I said, I'm mindful of that, and would note that I understand that this was a strange time in our society and our culture with COVID, and that a lot of those safeguards, I know that places were working around them, trying to figure how to keep things moving. So I understand that as well. One of the first things you learn as an attorney in law school, they talk about what's called the guilty mind. And that is when somebody violates the law or breaks the law, they go through a mental process that they have to understand that it's what they're doing is wrong and then act on it. I, unfortunately, in my 10 years as a judge and my time before that as a prosecutor, have seen these types of cases. They almost always happen the same way. Somebody's in a position of trust. There's some circumstance where they see a flaw in the system. And like I said, I think in this case, a lot of it had to do with COVID. And they always start with the same thing. They usually take $100 or $200, usually with the intent to pay it back because the bill's due, something's going to happen. They take that money. A lot of times people do pay it back, and they think, oh, well, that worked. So then they take money again, and then they don't return it. In this case, I think that it showed that you had some concerns. I'm reading from page 5 of the pre-sentence investigation report. You had health concerns, you had medical bills, your spouse had employment problems. You started by taking a few $100s in the middle of 2020 to pay for bills and mortgage, and it always is the same thing. It not grows. It grows over time, and once you learn you can do it, you do a little bit more, and every time you do it, you make that same justification, that mental process to justify it in your own mind, and almost every case ends up like this, that there are hundreds of thousands of dollars taken, the person that took the money usually has no idea where the money goes. It takes over time. In this case, when you were first confronted about it, you were confronted by the people from the church who admitted it. Then when the officer reached out to you, you denied it. They did a forensic accounting, ultimately found the large amounts of money taken. Would note, I'm reading from page 2 of the pre-sentence investigation report, that notable purchases that Officer McDonald saw was a purchase of a 4-wheeler from Action Motorsports, childcare, furniture, manicures, dog waste cleanup, mortgage, as well as supplies and labor to finish the basement of your home. So it did grow to more than just emergency money. And that is that same process that we talk about and I've seen. And ultimately in this case, to probably a sum that's incredible to your mind as well. That of the $339,175. So the question is, what do we do? You do not have a bad record. I have considered the argument of probation. This court is governed by Idaho Criminal Rule 1925-21, which requires me to look at the process. I must consider protecting society. People and employers that employ people need to be able to trust them with assets. And so certainly protection of society is an issue in this case. There is a deterrent effect that people need to know that if they steal from any organization, not just a church. I mean, I think people are more sensitive because of it's a religion or a church, but I've had very similar cases with stores and businesses, always almost the same thought process, and this court treats them the same, and that all employers need to feel like they can trust their employees to do their job. I mean, that's why they're paying you. That's why they agree to pay you. They teach you the skills, they bring you in. I must see the rehabilitation, and the court is, I'm less concerned about that. There was no history of drug use, none of that. But rehabilitation in this case was a long period of overspending, a long period of living on somebody else's money. And that, once again, that's like any other habit. Also, punishment or retribution for wrongdoing. And like I said, all of those are important in this case. The court can't do anything about the violation of trust, and I know that people deal with that, and frankly, I know you dealt with that. You recognize these are good people, and you took advantage of them, and you know that, and you'll have to deal with that as well. The report talks about how you were remorseful for your actions. You did express regret. You expressed regret again today, which I found appropriate. You have 3 children. The court had reviewed some of the mental health concerns. You've been going to counseling. There's other issues. You lack an extensive criminal history, and I'm just reading from page 13. And I understand what Mr. Malik argued too, because all of this seems like, okay, it's going to be a recommendation of probation. And then the next sentence is, however, the extent of her criminal actions over the period of 2 years is extensive. And I agree with that. I mean, I do not attend that religion, that church. However, I know people that are religious, they give what they can. And when this information is out there that there was over $300,000 taken, that's difficult to deal with. And the PSI continues to go on saying, considering the severity of her actions toward an organization that she worked for, also considering the plea agreement, the pre-sentence investigator did not feel probation was appropriate and recommended a period of incarceration. The court had gone back and reviewed Idaho Code 1925-21 relative to that question of whether I should place you on probation or confine you to prison. And based on all those factors, considering the judgment before me, it's going to be the judgment of this court to be sentenced to custody out of the Department of Corrections as follows. For count 1, the charge of grand theft for a period of 3 years, followed by an indeterminate term of 10 years for a total of 13 years. For count 2, the tax evasion for a minimum term of 2 years, followed by an indeterminate term of 3 years for a total of 5 years. And for the perjury charge, 3 years, indeterminate term of 10 years for a total of 13 years. I am going to order all of those run concurrent. This was kind of the same common scheme or plan, consistent criminal activity. I've considered probation. I have considered a retained jurisdiction. I'm not going to do either of those. I feel like something doing less than this would be minimizing the seriousness of the action. I'm only going to order a tiny fine of what I would normally do. I feel that any money paid should be paid in restitution, so I'm going to order $100 on each of the 3 counts. Court costs, payments in the Victims Relief Fund as required. I will order restitution as ordered in the amount of $339,175, as set forth in the order, with the Presbytery of Kendall to receive $1,000 and the rest to go to the insurance company. I will give you credit for any time that you've served up to now, and will already be taken into custody. I do wish to advise you of the right to appeal to the Idaho Supreme Court from this judgment conviction. You have the right to be represented by an attorney on appeal if you cannot afford one. One will be appointed for your public expense. However, you only have 42 days from today's date to do that. You also may have rights under Idaho Criminal Rule 35 if you feel the sentence was illegal or unduly harsh. You have 120 days for that. You also have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the date your right to appeal expires. If you have any questions about that, please consult with Mr. Malik. I do wish you luck, wish you well. I am sorry both for you and for the Presbytery. However, at this point, the court would already be taken into custody for execution of the sentence. Other than that, we will be in recess on this.